my name is Amy Kristen Sanders, and I'm an associate professor in the School of Journalism and Media at the University of Texas at Austin. And I'm really excited to chat with you and talk about my paper, COVID-19, Death Records in the Public Interest, Why Now is the Time to Push for Transparency, at this year's NFOIC conference. My paper emphasizes the importance of access to death records, including death certificates and autopsy reports, during a time of public health crisis. As you probably know, our access to these records varies dramatically from state to state, and even the Supreme Court cases on the issue don't provide the important clarity necessary, given the importance of these records. I'm looking forward to chatting with you about ways that advocates can approach their state legislatures to get positive change in this particular area.
Okay, wait a minute here. Just a second, everybody. Are you not seeing the video? I see a message. Video's not showing. Is that true? Okay, well, let's get the video to show then. All right. That is odd. Let me try again. Not well. Video isn't showing not well. Okay. All right. I apologize for that. Let me try this again. That is bizarre. Okay, let me know in chat if it doesn't show up again well.
My name is Amy Kristen Sanders, and I'm an associate professor in the School of Journalism and Media at the University of Texas at Austin. And I'm really excited to chat with you and talk about my paper, COVID-19, Death Records in the Public Interest, Why Now is the Time to Push for Transparency, at this year's NFOIC conference. My paper emphasizes the importance of access to death records, including death certificates and autopsy reports, during a time of public health crisis. As you probably know, our access to these records varies dramatically from state to state, and even the Supreme Court cases on the issue don't provide the important clarity necessary, given the importance of these records. I'm looking forward to chatting with you about ways that advocates can approach their state legislatures to get positive change in this particular area. See y'all soon.
Three primary points emerge from this paper. The first being that the Florida High School Athletic Association is the primary regulatory body for athletics in the state of Florida. The second point being that the association has certain regulations, requirements, that principals ensure that concussion protocol documents are maintained at the schools that they helm. The third point is that we at the Bruckner Center at the University of Florida sought the number of concussions that were documented at these high schools that had something called an 8A classification for varsity football teams, and we received a mixed bag of responses, some including no response, some including refusal, citing privacy concerns, and some including agents for the school or the school district proffering the numbers but not the actual documents themselves. There are a lot of reasons for these, and I will be happy to detail them more.
Hi all, my name is Alamin Sumar, and my paper was an examination of how governments have used a 1996 federal law, the Health Insurance Portability and Accountability Act, as a basis for not disclosing certain kinds of information about the coronavirus to the public, and whether these non-disclosures actually do comply with the law. And the key takeaways are that governments have often ignored sort of central parts of HIPAA in making these decisions. One is a required by law exception, which applies to public records requests, the import of which is that governments can't withhold information under HIPAA unless it's also exempt independently under state law. And sometimes governments have ignored the covered entity requirement or the requirement that the information be protected health information. So I hope you enjoy the paper, and I look forward to hearing any feedback. Thanks.
Hello, this is Professor Shubha Ghosh. I teach at the law school at Syracuse University College of Law, and I'm excited to present the paper, Liberating Government's Materials, Removing Copyright Obstacles to Transparency. This is a paper about the recent Supreme Court decision in State of Georgia versus Public Resources Org. And the issue in the case that the court resolved had to do with copyright in legislative materials, and it extended its centuries-old holdings regarding copyright in judicial opinions to legislative materials in a dispute involving a public interest organization that was making available digital copies of Georgia state legislation, as well as the legislation in other states. So I look forward to talking about this paper and the ruling and its implications for not only for legislative materials, but for access to other government materials as well, including tax records, executive materials, codes, and so forth. So I look forward to meeting everyone and sharing my work and learning from others. Thank you.
Hello, I'm Mauricio Astudillo Rodas. I'm a doctoral student at Rutgers University. I'll be presenting my paper called Internalizing FOI Law in a Developing Country, Insights from Colombian Public Servants. I revised how civil servants operationalize FOI law and its contribution to a reduction in corruption. Here, I'm interested in seeing how public servants interpret FOI law, because it can be understood as intrinsically valuable or as an instrument. I use the Colombian Employee Viewpoint Survey, and my main conclusion is that when employees perceive transparency as instrumental, they're more prone to act against corruption. Probably, they're receiving more managerial tools that they can use on a daily basis to act against corruption. These results raise questions regarding how public employees are being trained in transparency and FOI laws, and how they're adjusting their behaviors according to the information they receive. Perhaps when showing these policies, when doing this training, when communicating these procedures, organization leaders may avoid narratives that follow abstract ideals based on ethical and normative standards because the results may not work. Public employees, they prefer receiving more tangible tools that they can use on a daily basis. Thank you.
Hi, I'm Megan Craig, an adjunct professor in the Newhouse School at Syracuse University, and I was only a small part of a months-long project by undergrad Madeline Davison, Knight Chair Jody Upton, and Sarah Cohn of ASU to assess secrecy in death records in the United States. Our research addressed the history and current status of death records access, as well as potential solutions to the problem of unequal access across states. We evaluated who can access death records in various states and interviewed several data and investigative journalists who have attempted in various ways to cover the pandemic and other death records dependent stories to find out how laws in different states affected their reporting. We identified several issues. First, that only 12 states follow death records access laws that could be categorized as open, meaning virtually any member of the public can request and access those death records. Second, that several states require certain information, including cause of death in some cases, to be withheld from public access. And finally, that in 33 states, death certificate records are closed, leaving no chance for the public to access this vital information, or at least no chance to do so for several decades after someone has died. In these cases, we could now report on causes of death for those who died in the pandemic of 1918, but not the one in which we currently live. Death records are crucial to reporting on current crises and holding those in power accountable. Only with full public access to death certificate information can we tell the stories needed to protect public health and guarantee accuracy in this first record of history. Thank you.
I'm Jonathan Anderson.
I'm Sarah Wiley.
And we're graduate students at the University of Minnesota.
Our paper empirically tests the ability to obtain structured data through public records at universities across the United States.
we found a mixed bag of both positive and troubling findings. On the one hand, most universities thus far have been able to produce some structured data without imposing a fee, and many have done so in a relatively timely manner.
However, numerous universities claimed there were no responsive records to our requests and that they would be required to make a new record, which is highly unlikely in the age of databases.
So we look forward to discussing our study with you and learning about others' research as well.
My name is Michael Karen-Nicholas, and I'm the Wikimedia Fellow at Yale Law School's Information Society Project. Over the past decade, I've worked to build and improve right-to-information systems across a range of different cultural and developmental contexts, from Kazakhstan to Afghanistan, from Mongolia to Malawi to Montenegro. If there's one thing all these systems have in common, it's institutional resistance. For every right-to-information law that exists, there are officials gaming ways to get around it. And the most progressive right-to-information framework in the world is worthless without an effective system of oversight to ensure that officials actually comply. My paper provides a comparative analysis of the different global approaches to right-to-information oversight, surveying the different models that have been developed and their strengths and weaknesses. My initial lens for this analysis is through the recent amendments to Canada's Access to Information Act, which transitioned the Information Commissioner to an order-making structure, albeit one with some limitations. By presenting this new model in the context of other global structures, my paper provides clear recommendations for developing a strong oversight system. I'm very much looking forward to the discussion on September 30th.
Hi, my name is AJ Wagner, and I'm going to give you the briefest possible overview of my paper. It was a study premised on a FOI audit or a field experiment across 1,002 requests across 9 state laws. I was trying to get geographical diversity in key legal areas, and then general reputation of open government in states. The dependent variables, outcome, time, and communication. Outcome was positive, neutral, negative. Just trying to get some baseline understanding of how these laws function. And then the independent variables that I was running against, those dependent variables you can see here, but of most interest were the ones that were the strongest predictors by a long shot across all dependent variables, were a subject legislature and independent advocacy organizations, not unlike most NFOIC members. Thanks for tuning in. I look forward to talking with you about what drove these variables, but I do think they're noteworthy and hopefully have some application going forward. Thanks.
All right, good job, everyone. Great stuff, and I'm really looking forward to hearing more about these things. It's amazing. I'm honored to introduce the moderator for this session, Frank Lamonti. Frank is director of the Brechner Center for Freedom of Information at the University of Florida's College of Journalism and Communications. Before joining Brechner, in 2017, Frank was executive director of the Student Press Law Center since 2008. He's been a practicing attorney, an investigative reporter, a political columnist, and he's currently publisher of the new Journal of Civic Information that he launched. And I hope some of the papers from here are submitted and get published. I anticipate that'll be the case. Frank is a tireless FOI warrior, and we're glad he could join us for today. So, Frank, I'll let you take it from here.
Wonderful. Thank you, Dave, and thanks to everyone who submitted to this competition, and ditto to your kudos to Dan, Erica, and Maggie for a very well-organized conference with a wonderful variety of speakers. I'm going to take only a moment before passing it off to our scholars and presenters, but I did want to say, viewing the entire range of papers, not just the ones you'll hear in this presentation, but the ones you'll be able to listen to afterward, it really struck me, the most striking single thing I can say was diversity, and diversity in every way. Diversity in the fields from which the presenters came, diversity of the ideas and perspectives that they brought, diversity of the ranges of experience that we saw. We saw people like Jonathan and Sarah who are just getting started in the field, who are clearly the next generation vanguard of FOI scholarship and advocacy, and then people like Professor Ghosh and Professor Sanders, who are very well known in the field, well established established and have been leaders recognized for years, and then everything in between. And so it really speaks to, and we even saw people like Alameen Sumar, who are practitioners and not faculty at all, who submitted, and that's even more encouraging that this kind of research work is being done by such a diverse array of people, and it speaks to the strength and breadth of this community, and also the opportunities for people to do really impactful research even at an early stage in their career. So keep up that great work, and I dropped a link in the chat to the Journal of Civic Information, where we'd love to see some of these papers and your future work get published as well under Dave Coolier's editorship. So with that, let me kind of hand the baton to AJ Wagner first to talk about his work on the factors that go into state FOI compliance and what does and does not seem to move the needle. Can we unmute Jay? Yeah.
Can you see my slideshow now?
Can see you and now hear you. Great.
Great. Sorry, I'm not a Zoom person. We're a Teams campus. You're going to see a suspiciously similar slideshow as I had on the video. I made a little bit of a couple amendments to it, but for the most part, I'm just going to walk you through it with a little bit more detail. First, I would like to thank Frank and Dave for putting this together, and excited to dig in on the other research here. I think mine runs into a little bit of some of the other research as well, so hopefully we can build a little bit of conversation here today. Again, I walked through this already. Again, what I was trying to do was just address baseline operations of freedom of information laws, and trying to do it through 9 different laws, you know, just to see which variables, as Frank said, move the needle. But I think it's really important to notice what I asked for in all these states and counties was very, very simple records. I was just looking to see whether they could get me non-disputed, uncontroversial records, and whether they could do it promptly. And you can see I tried to get geographical diversity, but also I was really interested in specific legal elements. So I highlighted the different states just for variation in there. And then again, the dependent variables, outcome, time, communication, again, just looking to see how these laws operate really simply, right? And outcome, positive, neutral, negative, like I said in the short clip. Positive is stuff that was either affirmatively disclosed, so already posted online, or they actually gave me the record. Neutral was a no records response, and I have lots of thoughts about how I coded that. But then negative was failure, or they couldn't get me the records, or they refused to send them to me or email them to me, which has actually been resulted in a court case in Oklahoma that's before the Oklahoma Supreme Court right now. Then time, just a measure of days from request until first response, days until completion. Communication, how many times they ignored my efforts to communicate with them, how many additional contacts it took to get to the end, whether that was a failure or a completed request. And again, these independent variables, a little bit more detail, but not a ton more here. Subject bodies, there's a lot of variation, especially in state laws. Federally, obviously it's just the executive branch. In the states that I looked at, I was looking whether the judiciary was subject to the FOI law and whether the legislature was subject to the FOI law. Deadlines, this is something that I'm particularly curious about, and it seems like there's a growing amount of research suggesting that deadlines don't affect the speed, they don't affect the outcomes, but I'll come back to that. Exemptions, this was very difficult to quantify. I talked to experts in states, many of them are NFOIC members, and I think I saw Tom Kamenek on this, where I consulted, and a lot of the experts did not agree with my counts on exemptions. Each state has statutory exemptions. Florida, people think there's more than 1,000 of them spread across all kinds of different laws. So the exemption variable is a little bit fuzzy, but.
Hey, AJ, hate to interrupt, but your slideshow's not advancing.
Oh, no. Oh, boy.
That's okay.
Well.
There you go.
Can you see it now?
You sure can.
All right, we'll move along here then. And then state oversight offices, and I coded this, and I'd be interested to hear what Michael has to say about his research regarding state oversight offices. But I counted it as a state oversight office only if the office was independent from the state attorney general. They had investigative authority and they had binding authority as well. So my thought on that was there's a lot of ombuds offices around the country that don't have a lot of power or authority. So I was interested to see what like a full-throated oversight office could do. So ones that could investigate and ones that could enact whatever their decision or whatever their findings were. And then I threw in independent advocacy organizations, which seems a little self-serving for this conference, but I was interested to see what these organizations did, and I'll kind of come back to that a little bit as well. And then fees, the way I looked at fees was whether they provided an explicit fee or whether they provided no fees or whether they provided reasonable or actual costs. And then penalties was another one I was really interested in as well. And the way I coded it just between a 0 and a 1. And I was just thinking whether there was a one-time fine or if there was anything more than that one-time fine. So if it was more than a one-time fine, which is pretty common, that was a 1. And if it was a one-time fine or nothing, it was a 0. And then this is what my findings that I found were most interesting and things I want to highlight before turning it over was the significant variables. And you know, when you do a study like this, you just kind of, you know, you structure it and then you set it to go and you see what happens, right? And I was really interested to see what resulted. The 2 strongest variables across every dependent variable, whether it was outcome, whether it was time, whether it was communication, was both independent advocacy organizations and subject legislatures. And I think those are both 2 really interesting findings. I think subject legislatures, I think that indicates something really specific about how a state is operating and whether a state is operating in good faith. Generally, these are going to be legislatures that have chosen to become subject to a law. And, you know, when you think about what a government official, what a politician is trying to do, it's a very interesting choice. And there's not a ton of research out there. Again, federally, it's not really an issue. But then I think when you look at our significant variables and not significant variables, I think there's a really interesting interplay between independent advocacy organizations and state oversight offices. I don't think the research suggests that state oversight offices aren't particularly effective. And I think that there's a lot to think through there. And again, I'm interested to hear what Michael has to say. But I think the one that I come back to is the Iowa Public Information Board, which is this beautifully designed oversight office. And it ensures representation across politics, across professional interests, across government. It's beautiful. But I think it's largely, and I would defer to the NFLIC members in Iowa right now, but I think it's not particularly effective. And then you look at a place like Florida where as recently as like 5 years ago, is a real simple office, and it was the same ombudsman or same individual who had been running it over and over again. He had very little resources, but he was considered to be very well respected, very knowledgeable in the state. But now since he's moved on, and I think DeSantis has changed things up a little bit. And again, you see that these offices, they vary whether they're really well structured or whether they're not very well structured. There's just so much in play in what they can and cannot do, and how whether they're politically motivated, whether somebody can influence the way that they operate, whether who's in charge, whether who's not in charge, the continuity, all these things matter in these state oversight offices. Whereas these independent advocacy offices, it's an entirely different focus, right? They don't have to play the political games. They can stay on target, they stay focused. And I think worth noting too is, when I looked at these, I didn't look at press rights organizations. I didn't count those. I only counted freedom of information organizations that were focused on open government issues. And I think it speaks to the work that are being done by NFOIC members and what they're able to do, whether it's training. I know in Washington, I talked to Toby Nixon. He said they are intimately involved with training that takes place of public officials or of custodians. And you think about the hotlines that they run, you think about all the different things they do, and then obviously the litigation, whether that's direct support for litigation, whether that's referring somebody to a lawyer. I think there's something with the independent advocacy organizations, and honestly, I think it's going to be a future study of mine, looking into how these organizations operate, what are the best ones, what are the pieces that actually move. But I think that there's something to do with independent advocacy organizations rather than those state oversight offices. And then penalties, I'll just do this briefly. I don't think they work because my paper opens with a look at Atlanta Mayor Kasim Reed's, his staff have gotten in trouble for frustrating requests, and she gets fined a small amount. But then you look at all these penalties across the country and how rarely they're applied. They don't quantify. They're not used enough to actually to produce any kinds of outcomes or results. So I'm not surprised at all to see that the penalties provision wasn't significant or didn't produce any different outcomes or results. And with that, I will leave it there. I look forward to hearing from the other scholars, and I hope to talk to some of you in the chat afterwards. Thanks.
Wonderful. Thank you, Jay. I have a couple of discussion questions that I've prepared, but in the interest of time, I'm going to reserve those for the end and see how much time we have. And if turns out that we hit our hard stop, then I'll reserve those for the breakout rooms afterwards. So with that, let me pass the baton to Michael Karanicholas, who is going to present his paper titled Overseeing Oversight about Canada's Access to Information Act, a really interesting topic that I learned a lot from reading. So thank you, Michael.
Thank you so much, and thanks so much for giving me this opportunity. My name is Michael Karanicholas. I'm the Wikimedia Fellow at Yale Law School, where I run the Initiative on Intermediaries and Information. I'll start with just a basic premise, which is that our right to information system is only as good as its oversight and enforcement structures. Hopefully that's an idea that's not going to be controversial to folks here. Implementation is an ongoing challenge, but it's also an international problem. And it's a problem that is ubiquitous across right to information systems. And because it is such a ubiquitous challenge, my paper takes a comparative approach, exploring different national oversight and appeal structures. You can basically divide global oversight models into three buckets. You have systems which are based on judicial review, systems which are built around a specialized oversight body like an information commission or commissioner, and then you have systems which are built around a more general oversight body like an ombudsman or human rights commission. The international standards in this space are pretty clear that having an administrative oversight body is preferable to just pushing oversight to the courts. That's because lawsuits are time consuming, they're expensive, and this is true for both sides, but it's particularly problematic from the context of requesters who have to fund their participation out of pocket, or for whom the value of information may diminish over time, such as a journalist working on a story. Having an administrative oversight body also allows for the development of specialized expertise in handling these cases. And there's also all kinds of ancillary functions that an oversight body can do in terms of monitoring compliance, interfacing with the public, and acting as a champion of transparency. So about half the oversight bodies in the world, looking at just at the national level, are able to issue legally binding orders to disclose information or otherwise to order bodies to comply with the law. And the rest are limited towards making recommendations. My research found that the divide between order-making power and recommendation systems generally tracks a structural difference, where specialized oversight bodies, an information commission, tend to have stronger enforcement powers, whereas general government oversight bodies like an ombudsman tend not to. And there's a number of possible reasons for this. As I mentioned, the Specialized Information Commission can develop a stronger level of expertise than an ombudsman, which may lead to greater trust in their decision-making. Specialized bodies are also expensive to set up. As someone who's been in the room with lawmakers trying to persuade them to spring for a specialized oversight body and a right to information law, it's way easy for them to just bundle that responsibility onto the shoulders of the existing ombudsman or human rights commission, often without giving them concomitant additional funds to handle those added responsibilities, which is obviously problematic. But what that means potentially is that legislators who are committed enough to set up a specialized body are more likely to be willing to subject themselves to binding authority. However, recommendation-based structures also have their proponents. So there's an argument that's made that they're cheaper to run because theoretically, legally binding orders require greater procedural rigor. It's also argued that recommendation-based systems are more conducive to fostering a more collaborative and less adversarial approach to promoting disclosure. The problem with that argument is that there are a number of international models, and I point to Indonesia specifically, which merge order-making power with a robust front-end mediation procedure. And there is even an argument that stronger order-making powers could support mediation efforts, and that's been made by Canadian information commissioners. They say that having order-making power in their back pocket strengthens their hand in trying to push governments to be more accommodating. Now, in terms of costs, obviously it's cheaper to bundle these duties in with an existing body than creating a new one. But the interesting thing that I found was that where governments set up a specialized body, but limited them to making recommendations, there's no indication that a recommendation-making process is quicker or cheaper than order-making power. Obviously, like, it's still cheaper to have that than going to court, but oversight bodies tend to be just as rigorous in developing their recommendations than in developing orders. And that suggests that a recommendation-based model, which is based in an independent oversight body, a specialized oversight body, actually just provides the worst of both worlds. So that sort of analysis of the findings takes us to Canada's reform process specifically and the lessons for global advocates. The Access to Information Act is one of the older laws in the world. It establishes an information commissioner which performs a number of promotional functions, but which is limited to making recommendations. Complaints about the system are almost as old as the Act itself. The very first formal review, which took place in 1987, pointed to this as a problem, and it's an issue that has come up about every 5 years since then with no major reforms. Now, in 2014, an ambitious young opposition politician named Justin Trudeau introduced an independent members bill that would have granted the Information Commissioner order-making power, a bunch of other, among other reforms. When he became a candidate for prime minister, those reforms were included in his platform, among other improvements. And obviously, he's now the prime minister. In 2017, his government did introduce a reform package, which was passed into law, the first major reform that law has seen since it was passed in 83 rather. But the reforms fell far short of what was promised in his campaign proposal. While these reforms reframe the Information Commissioner's recommendations as orders, there's no actual mechanism to enforce them, such as an ability to certify the decision with a court or direct sanctions for non-compliance. The reforms also allow for appeals against the Information Commissioner's decisions, which are carried out as a de novo proceeding. And that specifically has been criticized because it means that not only do the governments not really have incentive to follow the orders, but they don't really have an incentive to engage with the process at all before it hits the federal court. So where does that leave us? Well, one of the lessons from that reform process, as well as the preceding analysis, is that the devil is in the details with these systems. It's not enough to have an independent oversight body, or even to call what she does order-making power, because there's all kinds of clever ways for officials to hamstring that kind of a system. And the risks inherent in right to information rules have a tendency to bring that out. It also illustrates why when you have a reform process, you have to see it through and capitalize. Transparency advocates in Canada have been pushing for this for 3 decades. So to get to the finish line and then find this kind of a poison pill in the process is troubling. However, on that note, I will wrap up with a quick story that is a bit more optimistic from Newfoundland and Labrador. So in 2012, the government of that province proposed legislation which curtailed the powers of their Information and Privacy Commissioner and which substantially broadened exceptions to disclosure. That legislation was criticized by opposition parties and journalists, as well as by the Center for Law and Democracy, which is where I used to work. And we used a comparative law approach to assess the changes that were being proposed against a number of international frameworks, including some in the developing world. In response to that criticism, the Justice Minister went on the floor of the House of Assembly, the legislature, to say, basically, I've been hearing criticisms from this cheap, amateurish, two-bit outfit, the Center for Law and Democracy, and they're claiming that our reform process is worse than Moldova, wherever the hell that is. They say that our reforms are worse than Uganda. I don't even think that Uganda has a constitution. How dare they compare our rich democratic tradition to that country? And that's a slight paraphrase, but it's very close to an actual quote. So obviously, that attracted a lot more attention to the reforms. And we put out a press release clarifying our analysis, which also said that CLD is no stranger to working in difficult political environments. Over the past year, we've conducted projects in Kazakhstan, Myanmar, Somalia, and many other countries that are known for being particularly hostile to democratizing forces. However, this is the first time that the integrity and professionalism of our organization has ever been directly attacked by a political leader. And the headline the next day on the CBC was, "Watchdog Group Claims Newfoundland's Political Discourse is Worse Than Somalia." So that reform package passed, but the issue stuck in the public consciousness. And a year later, when there was a corruption scandal, everyone pointed back to those legislative changes. And ultimately, that scandal ended up bringing down the premier. And when her successor came in from the same party, he pledged to reverse the changes and improve the law. And that process resulted in a wide-ranging slate of reforms, which we were able to directly participate in. They actually flew me out there. And that ended up representing the biggest legislative step forward in a Canadian jurisdiction in recent memory. So I tell that story because the lesson there is, first, again, when an opportunity for reform presents itself, it is very important to capitalize fully. But also, I like to tell that because from an advocacy perspective, it shows that these things can go in weird directions. And even a step backwards can be an opportunity to sow the seeds of future successes by capitalizing on the moment to push the right to information to the forefront of the public consciousness.
Wonderful. Thank you, Michael. I appreciate your submitting this interesting paper. I wonder, we can talk afterward about this. I wonder if Justin Trudeau, given the scandal that he and his family are embroiled in right now, is rethinking his commitment to transparency of government contracting in particular. We could get into that more if we have time later. I want to hear from now Jonathan Anderson and Sarah Wiley, who submitted a paper that I will cherish because it addresses an issue that I get all the time as an attorney that has to advise journalists, called freedom of the database, that looks at the issue of accessibility of information now that so much of it is memorialized not in paper files, but in databases that the layperson doesn't always have access to querying anymore without an intermediary. So Jonathan and Sarah, thank you.
Thank you, Frank, and hello, everybody. Thank you for tuning in wherever you are. I'm Sarah Wiley. This is my co-author, Jonathan Anderson. And we're PhD candidates at the University of Minnesota, and we're also research assistants at the Silla Center for the Study of Media Ethics and Law. So just a brief background on this project and why we decided to do it. I had been working on a separate project with several data journalists surrounding potential liability around data scraping. But one of the things that kept coming up last year was that they were having trouble even getting access to governmental computerized databases or structured data. So just to kind of give a brief overview of what we mean when we talk about structured data, is we're talking about clearly defined data types that are in an easily searchable format like CSV or Excel file. This type of data really allows journalists to find patterns in documents and to be able to release that data to audiences so that they can interact with it themselves. We see this a lot with interactive maps, for example, like around shooting or even COVID data too. But I kept hearing these stories of, hey, you know what, I requested this information, which I know the government has, I know they've been collecting it, but they came back saying, oh, well, in order for us to even search the database, that is essentially creating a new record. And we're under no duty to do that. So record request denied, right? The other story I kept hearing often was we requested this information in a CSV or Excel file, which is clearly the format that it's in, that we know that it's collected in and stored in. But in 6 months, we got this box of printed screenshots of an Excel database or printed emails. And we hear this critique all the time, right? The journalists are super frustrated with getting boxes of printed emails, super frustrating. So in thinking about this and in talking to Jonathan, we really wanted to empirically test if these kinds of denials were popular across states. And I'll let him take it away with our method and findings.
All right, thanks. So what we did is to do that empirical test, we filed public records requests with agencies around the United States. We chose the largest public university by enrollment in each state that did not have a residency requirement. And so that left 44 states. We filed 3 requests per university, and these requests varied in their complexity. So we asked for data on payments to vendors, data on payroll payments to employees, and an email log of the university's most senior administrative officer, essentially their president or their chancellor. The requests for vendor and payroll payments used the language asking for all entries in, for example, accounting or bookkeeping databases, and then we included or specified certain kinds of fields. If you go to the appendix in our paper, you can see an example of the request that we filed. So to give you just a sense, a very brief overview of the data, this table shows the data for the responses that we've received so far. I'll discuss just a few, namely the request outcomes, fees, and response times. So 35 requests have resulted in responsive data. Mostly these data were produced in full, but some did have redactions. For example, the University of Washington withheld the names of student employees in payroll data, asserting that that information was subject to confidentiality under FERPA. Universities in 10 requests produced data that were similar but not identical to what requested. So sometimes what would happen is the university would refer us to an online portal that would contain data similar to what we wanted, like salary information in aggregate, but not distinct payroll payments. And then 18 requests produced claims that no responsive records exists. And just to give you a flavor of some of these, I'll quote some language from some of the responses. For example, the University of Vermont's response said that Vermont's Public Records Act does not oblige the university to generate custom reports or create new records. The University of Hawaii's response said records could not be provided because the request required the university to, quote, create a summary or compilation from records, but that the requested information is not readily available. UCLA wrote back and said that while it had conducted what it called a reasonable and good faith search, it was unable to locate any existing responsive records. And it further argued that the California Public Records Act requires public agencies to provide access to certain existing records that are not exempt from disclosure, but that the act does not require the university to create new records to satisfy our request. And then the University of New Mexico, as another example, said that agencies do not have to generate new records if doing so would require more than a few keystrokes. In terms of fees, 45 requests produced data without any charge. 21 requests did require processing fees ranging from about $50 to more than $1,000, which we did not pay that if you're curious. In terms of response times, universities issued final responses within 10 business days in 39% of processed requests, with 80% of final responses issued within 30 days. And then in terms of the data actually produced, a lot of it was in Excel files, some also in CSV or PDF, and then others were referred to by web pages. I'm sorry, this is the table for our response times as well. I just had that out of order. Overall, it was a mixed bag of both positive and troubling findings. On the one hand, in about half of the requests processed thus far, universities have been able to produce some sort of structured data without a fee, and most final responses have been issued within a month. But on the other hand, some universities did seek to impose very significant and burdensome fees. And we thought what was most interesting is that universities often asserted that there were no responsive records, which we think is highly unconvincing in light of the widespread use of common accounting software and email services, and the fact that numerous universities were able to produce the responsive data as we requested.
So where do we go from here, right? Well, first, legislation, which I'd be happy to talk to AJ about after this. But the universities that denied our request based on the assertion that it required them to create a new record were located within states where both case law and statutes kind of allow for that conclusion or allow for very poor interpretation. In other words, there is no statutory authority for a requester to obtain a customized search of a governmental electronic database. Oftentimes this is the case simply because statutes are old, right? They don't even mention computerized databases, but that's not always the case. As Jonathan mentioned, New Mexico and Hawaii both denied a request based on it would make them create a new record. And both states have statutes addressing electronic databases. However, both statutes also leave room to deny requests if it requires a public body to create a public record. In Hawaii, for example, information that is not readily retrievable from the database in question constitutes a denial. In New Mexico, which we mentioned earlier, their Inspection of Public Records Act also specifically states that a customized search of a database is discretionary. So therefore, we really propose updating state laws to make it clear that searching a database is itself not creating a new record. And there, I believe, is a FOI, a federal case happening with the Reporters Committee right now that deals with this as well. Second, we propose that states should also require agencies proactively disclose the existence of databases that they use. I believe California is the only one that has such a requirement right now, which is interesting. But we highlight that it would also be helpful if they disclose a description of the fields of data that they collect as well. Disclosing such information would really help record requesters to target their records requests, which also gives agencies more time and availability in searching for records and processing requests as well. So in the case that legislation doesn't happen quickly, and we all know it doesn't, it will be helpful to kind of think through for journalists how and where this information is being held. So for example, if they think it's a local held database or if it's in the cloud, and what format and structure this data is in, right? Those things are going to be really helpful in order to target requests. Our third big suggestion, which I would love to hear from AJ and Michael about this too, is education, right? Education around with records custodians and education around kind of how to access this type of data. Oftentimes we got responses back that with astronomical fees due to labor, right? Records custodians often highlighted how much time this would take. They didn't know quite how to go about getting this information or compiling the information. So it might be helpful just to kind of talk them through that, right? Be open to discussing with them how to do that, because a lot of times they just don't really know how. But that is pretty much our implications and our proposals. But I want to say that the data is still coming in for our project too. And really it's becoming clear that the same information, as Frank stated, the same information, if it's on paper, is being denied if it's in a computerized database. And this is really becoming an issue and will become an issue in the future as we live in an age of data now, and we live in an age of governmental surveillance. So this is really going to require more research and more solution in the future. So we look forward to hearing everybody else's thoughts and ideas about this. So thank you.
Thank you.
Wonderful. Oh, thank you so much for all of these really enlightening and insightful papers. And we've got just about 8 or 9 minutes left. So I'm going to do a lightning round here. Just go around the room with a question for each presenter. If you just take 2 or 3 minutes, and then if we run out of time, we'll take it off to the breakout room. So for Jay, I wanted to give you a chance to explore just a bit a finding that you identified as a counterintuitive finding, which was that fee limits in state statutes don't actually wind up moving the needle in a pro-access direction and may in fact be counter-helpful. Can you talk about that finding and why you think that might be so?
Yeah, I mean, it's obviously speculation on my part, but I think, I wonder how these things are applied, and, whether the states that use ambiguous language, whether they say reasonable costs or actual costs versus those fee limits, like it just varies. And other than stuff that gets brought to the court, I don't know how much the legislation or the statute actually comes into play, right? So I would like to say that, there's a clear and obvious explanation, but I also wonder, how these laws are so loosely applied often, and how often the application is consistent with what the statute says. And just in filing those 1,000+ requests, you just get wildly different outcomes. And to come back to what Sarah was just saying, I think training is a big piece to it as well. So, I think it's hard to read too much into any of these statutes or the specific legal provisions, because the laws are often very loosely applied and loosely understood by custodians. So I guess that would probably be one of my biggest takeaways is that the specific provisions probably play a smaller part than what I thought they would when I started out the study.
Thank you, Jay. For Michael, this is a very unfair 2-minute question, because this could be a 2-hour discussion. But in just a couple of minutes, that Canada has not traditionally had the same deeply ingrained tradition of commitment to wide open discourse that is embedded within the First Amendment to the US Constitution as it's understood by our courts. And in fact, Canada has often cut the distinction between freedom of information on one hand and privacy and personal privacy rights on the other hand in a different place than US law might cut it. And I wonder if you could talk a little bit about the accommodation of the right to personal privacy and the right to access as you've observed it in Canada, given that we're now bumping up against this in everyday discourse here in the United States with things like access to data about COVID cases in schools, access to data about COVID cases in nursing homes and healthcare facilities, and the right to personal privacy is being invoked as a reason not to answer those data requests. Can you talk a little bit about accommodating the right of personal privacy and the right of access under Canadian law?
Yeah, so just to start, in terms of your framing of the question, I actually disagree with this very, very commonly held notion that the US is this absolutist on free speech, and then you have Canada and Europe on the other side that takes a very different approach. I think that when you really dig deeply into the weeds, you can find areas of the law that are more respectful of freedom of expression on one side of the board or the other, but it's not nearly as clear as that. And so I think that that's a very, very commonly held conception of the legal differences between the countries, and I think it's wrong. And someday I'll write a paper about that, but I haven't gotten around to it yet. And one of the examples of that, kind of building on what you said, is when you talk about the right to information, right? That's an area where I think Canada is advanced on the freedom of expression side in a way that isn't necessarily true in the US. The right to information in Canada is a constitutionally entrenched right. It's a limited right, it's a derivative right, but it was recognized by the Supreme Court as part of our Constitution. That's happened in a number of countries. The US isn't there yet. So when you talk about freedom of expression protections, free speech protections, that's part of it. And that I think speaks to the contextual differences between the countries. In terms of the privacy challenge there, like I have no problem saying that privacy protections are more advanced generally in Canada than they are in the American context. And partly that's because, and there I think it is more fair to look at it as more of a dichotomy with the US on one side and the EU on the other, and Canada moving closer to the EU side than the American one. Although there's also been legislative developments in California and potentially at the national level in the US. So even there, maybe it is moving in more of a kind of fuzzy and less black and white direction. But I guess the best way to answer that question is to point to the fact that every right to information law that's worth its salt, and I think the vast majority of right to information laws have some kind of a protection for personal privacy. within the exceptions. And whether or not that is narrowly entrenched or widely interpreted is mostly a question of interpretation and a question of the traditions and the norms that are entrenched inside of the system, much more than the broader and actual phrasing of how it works. Because these systems, the different laws almost always frame this as you have to redact information that violates personal privacy. And the interpretation of what exactly that means is usually going to be up to the guy on the front line making the analysis.
As much as I would love to dive into, thank you for that. As much as I would love to dive into Jonathan and Sarah's paper, I'm getting the hook here. I'm getting a signal that I need to hand this off so that Dave and Erica can introduce the instructions for people to go to the breakout room. So with that, I will thank our authors again. And Dave and or Erica, do you want to go ahead and get into the logistics of what comes next?
Well, sure. Thank you, Frank, and thanks for moderating that. And thanks to all of you who presented this really interesting stuff. Next, we're going to have the breakout room. So all the authors, go ahead and move into your Zoom rooms now. And then attendees will be able to show up here in a few minutes. For attendees, if you go down to the bottom of the main Whova page there, under the video, scroll down past the awesome presenters, past all the text, you'll see a list of the subsessions. Each paper is listed there. You'll see a little green camera thing and a little title. And so you just pick which one of those sessions you would like to pop into, and you can pop in and out if you want. There's Zoom rooms. You can only be in one at a time, but you know, feel free to pop in whatever you want, talk with the authors, ask some questions you'd like to ask. There's 9 of them there, and they're there to engage with you. So that is how we're, and they'll be around for a half an hour. So you'll have a chance to do that from 5 to 5:30 Eastern. Thank you all again for attending. Really cool. Happy this year with some neat research, and hopefully we'll do it again next year. So for those of you interested in submitting a paper, winning potentially $500 or $300 or $200, I guess is first, second, third, feel free to enter. We welcome it. Thank you all, and thank you, Frank, and thank you, Erica. And I'll see you in the breakouts.